Hello, good evening, and welcome to part 3 of the Parish Nurse Ministry's discussion on compassionate care for ourselves and those we love. I'm Maureen Pepin. I am a co-chair of the Parish Nurse Ministry. Tonight, we're thrilled to have attorney Jay Kearns from Kearns & Kearns PC join us to discuss important topics such as elder law, estate and probate law, special needs trusts, as well as other long-term care issues that may affect us now or in the future. Jay is particularly distinguished as Connecticut's first attorney to be board certified in elder law. A native of West Hartford, Jay attended Fordham University before going on to Syracuse University College of Law. He has authored and co-authored numerous articles and has been featured in Connecticut Lawyers Magazine, Modern Maturity, Business Week, and has made appearances on CNN, NBC, CNN Radio, and the Wall Street Journal Network. Jay has earned several accolades, including being named Connecticut Super Lawyer by Super Lawyers Magazine, and has been recognized as one of Greater Hartford's top attorneys by Harvard Magazine. Additionally, he was appointed to the Connecticut Independent Division of Autism Spectrum Services Advisory Council by the Commissioner of DDS. These are just a few of the many achievements, and they give you a good sense of his qualifications to speak on such important matters. Please join us in welcoming Jay Kearns to St. Patrick's St. Anthony Church.
Good evening, everybody. I'm going to be speaking about things that nobody likes to talk about, think about, or do anything about, and that's death, dying, and disability. Back in the 70s, in the state of California, they created a document called the Living Will. And unlike your last will and testament, which leaves property to people upon your passing, the Living Will indicated what kind of medical directives you wanted if you were unable to speak for yourself. In 1984, there was a Connecticut Superior Court case called Sandra Foody versus Manchester Memorial Hospital. Sandra Foody was a woman who for 32 years had suffered from severe MS, and she was brought to Manchester Memorial Hospital in a comatose state. Her father, Kenneth, had been named the conservator for her, which means that a probate court had found her incompetent and put someone else in charge of making medical decisions for her. And at the time that she presented herself, the question was, should the hospital keep her alive on artificial life supports? And what the father did was he brought a lawsuit against the Attorney General's office, the state's attorney, and the physicians in the hospital itself, not seeking financial damages, but to seek an injunction to prevent anyone from interfering with Sandra Foody's dying process. And the Superior Court judge granted the injunction and found by the medical evidence that nothing further really could be done for Sandra Foody because she was in this comatose condition. And so they allowed for her to pass away. In 1985, the state legislature, working along with the Archdiocese of Hartford, created a living will form that became our statutory living will. And the problem with that form was that it only pertained to people who were terminally ill. It didn't say anything about being in a persistent vegetative state. So in 1989, there was a Connecticut Supreme Court case called McConnell versus Beverly Enterprises. And Carol McConnell had been a OR nurse, operating room nurse at Danbury Hospital. She was in a car accident and she was brought to Danbury Hospital and then discharged to a nursing home never regaining consciousness. And for 3 years, she was fed through a gastric tube, which some people call the G tube. It's a 3-foot-long tube that's inserted into your stomach to keep you alive with nutrients. And at the end of 3 years, her husband went to the Danbury probate court, became her conservator of the person, and much like in the Sandra Foodie case, brought an action against the state's attorney to prevent anybody from being charged with a crime, brought an action against the Attorney General for the state of Connecticut so that no one was civilly liable for interfering with Carol McConnell's care, and again sued the nursing home and some of the doctors to get injunctive relief to prevent anybody from interfering with the withdrawal of life supports. There was a trial, and at the trial, a doctor by the name of Ruxin found that even though Carol McConnell was in a coma, he testified that this ultimately would result in her death, and therefore it was a terminal illness. Now you have to remember why the doctor was doing that was because the living will statute applied to people who were terminally ill. The living will statute at the time did not apply to people who were in a persistent vegetative state. So what happened in a lot of the right to die cases in the 80s and 90s is you have David versus Goliath. Goliath is the state, and typically the attorney generals would come in on behalf of the state arguing, number one, we have a duty to preserve life, we have a duty to prevent suicide, we have a duty to police the medical profession. And on the other side was David, which is the individual, saying, I have the right to liberty and self-autonomy. I have the right to do what I want with my own life, and I have the right to deny myself medical care or medical treatment, which is essentially what the conservator, which is kind of like a legal guardian, was doing. And so you had this clash, and the Connecticut Supreme Court did some mental gymnastics, as I call it, because the Chief Justice at the time said, look, the statute as written indicates that nutrition and hydration has to be provided to those people who are terminally ill. However, we don't believe that the legislature thought that a gastric tube was the same thing as a cup or spoon to give someone nutrition or hydration. So the Supreme Court ruled that the life supports could be removed from Carol McConnell, and Carol McConnell passed away. So here you are running a nursing home, and you have a living will says food and nutrition must be provided, and it's a living will for people who are terminally ill, they're not in a persistent vegetative state, and your highest court has just found that somebody who is in a coma, in essence, is in a terminal condition, and you have them interpreting what the legislature thought about using a spoon or a cup versus D4W, which is a dextrose water IV that typically people in a hospital are given, or nutrition through the gastric tube. Well, things became a little clearer in 1990. In 1990, in June, the US Supreme Court came down with a decision called Cruzan versus Missouri. So Nancy Cruzan was a young woman about age 31 who was traveling down the road in her Ford Bronco when she flipped the car over, and she was thrown from the car into a drainage ditch where she lay underwater for 8 to 12 minutes before they fished her out. And Nancy Cruzan, much like the Carol McConnell case, had been in a coma for at least 3 years before her parents decided to pull the gastric tube. And so when they did, the probate court in Missouri agreed with the family and said, you can go ahead and you can pull the gastric tube. It's clear that she is in an irreversible condition. She is not going to recover from the coma. There had been medical testimony, and the court sided with the family and directed that the gastric tube be pulled out. The Attorney General for Missouri was a fellow named John Ashcroft. Later on, he also served as a senator from Missouri. And the Attorney General, again, citing the preservation of life, policing of the medical profession, and preventing suicide, came into this proceeding and took an appeal, arguing that the gastric tube should not be removed from Nancy Cruzan. And the family also, again, was arguing liberty, the right to self-autonomy, and the right to be free of government intrusion, and a right to privacy. And the Missouri Supreme Court heard the case and indicated that in this particular situation, when Nancy Cruzan was at a party and made a statement to witnesses that she would not want to be kept alive through artificial life supports, they weren't sure whether or not she was thinking that at a later date she might in fact be in this condition, or whether or not she had had a couple of drinks or was saying this comment in jest. And therefore, the Missouri Supreme Court remanded the case, meaning they sent it back down to the probate court for further evidence. Well, at that point in time, the Attorney General decided that he was going to run for U.S. Senator, and this was not going to be a case that he wanted to get involved with any longer. So he withdrew his appearance. If you have a quarrel with somebody and your opponent or your adversary leaves the scene, there's no more argument. So when the case was remanded back to the same probate court that several years previously had ordered that the gastric tube be removed, and the state is no longer a party to the case, the probate judge issued the same decision that he did several years earlier, arguing that the gastric tube should be removed, and Nancy Cruzan died shortly thereafter. So now, Congress was unhappy with this decision. They're unhappy with the U.S. Supreme Court decision. And so what happens in the three branches of government is that if the court comes out with a decision that you don't like, you can create legislation and paper over that decision with law. So Congress then passed the Patient Self-Determination Act. And the Patient Self-Determination Act tells you that anytime you go to a hospital, you go to a nursing home, you become a patient of the Visiting Nurse Association, you enter hospice, that you be given a packet. And the packet contains the documents that we call advance directives, because they direct in advance what you want to have happen if you're not competent to tell people what you want for medical treatment. And so since '91, this packet had been handed out to people. It's a federal law. And in it is the living will, a designation of conservator, the appointment of a healthcare representative, and perhaps organ donations for those people that wish to do so. And it also has questions and answers about how you will be treated in the event that you have this packet, you have these documents. But the biggest problem that I always saw with the Patient Self-Determination Act is that your primary care physician was exempted from the law. It applied to institutions. It applied to the hospitals, it applied to the Visiting Nurse Association, it applied to the nursing home, the hospices. But your PCP was not required to get involved in this. And I always found that that was paradoxical, because if you think about it, the living will doesn't take effect unless your primary care doc is of the opinion that you're no longer competent. And when you're making decisions underneath a living will, or you are engaging the healthcare representative because you don't have capacity, again, it's a decision between the doctor and the family. So who else should be talking to you about what your wishes are in advance? It should be the primary care physician. So we have had this change in Connecticut from '85, when we first had the living will. In 1992, the state legislature changed the living will from being just for people with a terminal illness to being applicable to people with a terminal illness and being in a persistent vegetative state. And in 1992, as a reaction to the Cruzan decision, we now had this new person called the healthcare agent. And the healthcare agent could make decisions at the end of life in terms of informing the medical professionals what your wishes are, and number two, enforcing them like your bodyguard. And then we had a third document called the Power of Attorney for Healthcare. So if I give anybody a power of attorney, that individual is called my agent, and I'm called the principal. It arises under agency law. And sometimes with the power of attorney, it's a fancy word for agent, because the person you name in the power of attorney is your agent. An attorney is your agent. They represent you. But there was all kinds of confusion between the healthcare agent, whose duties arise at the end of life, versus the power of attorney for healthcare, who under Connecticut law at the time could make any healthcare decisions except withdrawal or withholding of life supports. So the power of attorney could make decisions about surgery, medication, transferring you from one hospital to another hospital, nursing home to nursing home, but they could not engage in end-of-life decision-making with withholding or withdrawal of life supports. And the healthcare agent only informed the doctor of what your wishes were and enforced your wishes. So if you fast forward then to 2006, the state legislature realized that there was this confusion between the healthcare agent and the agent who made healthcare decisions in your power of attorney. So that year, they abolished the healthcare agent and the power of attorney for healthcare under Connecticut law. So today, and since October 1 of 2007, we only have a power of attorney for finances under Connecticut law. We have a different individual who's charged with making healthcare decisions called the healthcare representative, not the power of attorney for healthcare. It's not called a proxy. That's a word they use in Massachusetts. And we no longer have the healthcare agent. So we have these different documents that are advanced directives. What I always advise my clients to do is to sign a form called the Healthcare Instructions. The Healthcare Instructions contain multiple documents in one. The first paragraph is the living will. The second paragraph is the appointment of the healthcare representative and a successor. The third paragraph is a designation of conservator of the person. In the event that there's a dispute, you simply go into the probate court, not the trial court like Foodie or McConnell. You go into the probate court to try and resolve end-of-life decisions. And then the last part of the healthcare instructions is the anatomical gifts or organ donations. In my practice for years, I have two major changes that I make to my healthcare instructions. The first one is rather simple. If you look at the Connecticut form, you just put in the name of the healthcare representative. It doesn't ask you what town they're in, what state they're in. And so if you had someone named Jones or Smith, I'm sure Google will give you thousands of Jones or Smiths if you were looking for a healthcare representative for someone. So what I always like to do is identify the name and the address and put in their phone number. Decades ago, AT&T had this commercial called Reach Out and Touch Somebody. If you think about it, this document is a communications tool. It's not meant to be hidden in the safe deposit box or in a desk drawer. I always tell my clients, you give it to the people who are going to be making the decisions, and you give it to your primary doc, because those are the people who are going to be making end-of-life decisions for you. So that's the first thing I do, is I put in the address and the phone number so that you can locate the healthcare representative. The second thing I put in is what I call the universal HIPAA waiver. HIPAA is not the animal in the zoo. It stands for Health Insurance Portability Accounting Act of 1996, and part of it took effect on April Fool's 2004. And what that law requires is that your medical information is protected, it's private, it cannot be revealed to anyone without your signature. But here's the problem. If you're incompetent and your healthcare instructions have sprung into effect, how are you going to sign a HIPAA release? That's why I put mine in the document that everybody's searching for underneath the Patient Self-Determination Act. These facilities by federal law are required to ask you, do you have a living will? Do you have the healthcare representative? Do you have the healthcare instructions? And if you do, I want them to find the contact information for the decision maker and indicate that HIPAA is not applied to the individual who needs to make informed, intelligent decisions. Because let's face it, when you make the decision to pull the plug, you can't change your mind later. So let's talk about the living will for a minute. The living will on its face is triggered when you no longer can make decisions for your health care and you cannot direct your doctor. That's when the living will works. And it indicates that you are in a terminal condition. And the terminal condition means, again defined on the face of the document, that if you are unable to direct, if you are unable because you're incompetent and you are in the final stages of a terminal illness and your doctor is of the opinion if we pull you off the life supports, you're not going to survive, that is the first prong of the living will. The second prong of the living will describes being in a persistent vegetative state or being permanently comatose. It goes on to say three things. Number one, you are not aware of who you are. You're not aware of yourself. Number two, You're not aware of the environment around you. You don't know where you are. And number 3, you show no behavioral response to the environment. What does that mean? It means if we flash a light in your eyes, your pupils don't dilate and you don't blink. If we hit you with the rubber mallet, there's no reflexes. If we prick you with a pin, you don't feel any pain. That's what it means when you show no reaction to the environment around you. So if you are on either prong of the living will, again, for it to work, you have to be incompetent, and if we pull you off the life supports, you're going to die of the terminal illness, or you're still in that persistent vegetative state. You're then saying, I don't want artificial respiration, a respirator, ventilator. 2 is, I don't want CPR. Now, a lot of my clients get confused about the CPR part because they're thinking that if they walk out of my office and have a heart attack and they hit the pavement and the EMT comes and spies the living will, that the EMT is going to stand around and do nothing. The CPR part says, I don't want CPR to bring me back into this condition, whether it be the final stages of the terminal illness or the condition of being in the persistent vegetative state. Having a heart attack is not a terminal illness. And although you may be unresponsive at the time that you're having the heart attack, it's not defined as a persistent vegetative state or a permanent coma. So you're saying you don't want the respirator, you don't want CPR, you don't want artificial nutrition and hydration. So the hydration is the dextrose water that you get in an IV, and the nutrition might be the Ensure that you receive in a gastric tube in your stomach. Pain medication is mandated under Connecticut law because we're not barbarians. And so we keep people comfortable. So in the hospice arena, it's called palliative care, and you get morphine, you get painkillers to maintain your comfort. That's what the living will further says. It also says that you're not taking your life. It's not euthanasia. It's not suicide. You know, this is a natural event that's happening. And you're saying you don't want your death to be unreasonably prolonged. Because that's one of the main fear that a lot of people have is, I'm out of control, I want quality of life versus quantity of life. And I don't want to be kept alive forever on machines. Because when they first came out with life supports, the 50s, maybe the 40s, these were temporary measures that were intended to stabilize people after major surgeries. They were not intended to keep people alive for decades. So that's the first part of the healthcare instructions, is the living will. In the healthcare representative section, you're naming someone, again, with specificity. You're identifying their name, their address, their phone number. And that person is required to act in your best interests. So they really have to have a good idea of what you would want. We call it substitute decision making. Part 3 in my document is the HIPAA waiver, which applies to anybody who reads it. You must provide the protected healthcare information to these people who have been nominated as the healthcare representative. Part 4, if there's a dispute, you go into the probate court. I probably had 4 contested right-to-die cases in my career. I used to be appointed quite a bit for right-to-die cases when Hartford used to have 4 hospitals. And yeah, these were never fun, but They're always memorable. And then part 5 is the organ donation, where you're either going to donate specific organs, and sometimes clients will say, I want my eyes to go to the eye bank, I want my kidneys to go to the kidney foundation. You can tailor it any way that you want. The document requires 2 witnesses to it, and usually you execute it like a will, where the 2 witnesses are swearing to the notary that they saw you sign the document, in the event somebody wanted to undermine it or try and contest it. Anybody have any questions so far? The durable power of attorney under Connecticut law is strictly for financial affairs. It has absolutely nothing to do with health care. It's all part of your planning. Estate planning is boiled down to 2 different areas. One area is you're planning for your disability. That's number 1, the healthcare instructions. And number 2, it's the power of attorney for finances, because if you're in a coma, if you had a stroke, then someone can handle your healthcare decisions and someone can handle your finances if you cannot. A will or a trust is the estate planning in the event that you die. You are directing who's going to be in charge as the executor or the trustee and where your assets are going to go. Well, let's talk about that. I had a meeting with some colleagues, and the colleagues are in charge of making healthcare instructions for an individual who now has severe dementia, where he wakes up every morning and he's not sure where he is. And he had almost died about 2 months ago. And one of the decision makers, it's 2 ladies, one of the decision makers was unsure about different types of care. And one was DNR, do not resuscitate. The other one was DNT, do not treat. The other one was DNH, do not hospitalize. And the last one was DNI, do not intubate. And so we had a discussion around the healthcare instruction, and I pointed out the living will is just like it says. It's for somebody who's permanently in a coma or somebody who's in the final stages of a terminal illness. But here we had this patient with dementia, and he's not in either situation. Although, when he was being treated at the hospital, he kept telling the doctors that he did not want aggressive treatment. He just wanted to die because the treatment was very painful. And so we then had a discussion about going forward, what's the roadmap going to be as different situations present themselves with this particular patient. And we had a discussion that this individual is now 91, and as I indicated, every single morning he's not sure where he is, and he's extremely forgetful and confused. So we went through when would we hospitalize him and when would we not? When would we have him treated perhaps with antibiotics if he had the flu or he had some other temporary ailment? What would we do if he had a massive stroke, which sometimes goes with dementia? But that's where the healthcare representative comes in more than the living will. And that's why it's so important to have the healthcare representative. I'm a big fan of using what's called the healthcare instructions with the multiple documents combined together on 2 pieces of paper that are stapled together, because it's very simplistic. I sometimes have clients coming in and they've got 5 separate documents. They've got the living will on 1 piece of paper. They got the healthcare representative on yet a 2nd piece of paper. They got the designation of conservator on a 3rd piece of paper. And you wonder, sarcastically and cynically, if the lawyer is charging a higher fee based upon separate documents instead of having 1. But that's me. So I adhere to the KISS principle, which is keep it simple, sweetheart, although I'm sure everybody here has heard different versions of that. And the healthcare representative is something that's very necessary. The living will, I tell people, it's like a wish list. If this happens, here's what I wish. But the living will by itself is not enforceable. The healthcare representative enforces your wishes. The healthcare representative is your spokesperson. They do the talking if you're bedridden and you're not competent and you can't tell anybody anything. So that's why the healthcare representative is so important. And again, hand in hand with being the healthcare representative, you don't want to go to a hospital or a nursing home and have someone say, no, I can't let you look at the chart because that's protected underneath the HIPAA rules. I'll tell you how ridiculous it is. I have a client, and this client for the last 1.5 years has amazed me because in January of 2023, she's always had chronic heart failure. But like the ever-ready bunny, she just keeps on going. So I was told in January of 2023 that she would be dead within an 8-month window. I talked to her last month, still chugging along. But when she was at an area hospital, I had a doctor call my office because the lady doesn't have anybody else except me to make the healthcare decisions. And so my receptionist said, well, can you please tell us what patient you're calling about? No, I can't. That's protected by HIPAA. It's ridiculous. Somebody's name is not protected by HIPAA. And especially if they're calling me, they're not calling me to talk about the Red Sox or the weather. They're calling me because it's an emergency and they're either looking for my consent to perform some kind of medical procedure, or they're letting me know what's going on with the client because they might be discharged from a hospital to a nursing home. But I figured, okay, if you won't give me the client's name, I'll call you back, which I did. And the receptionist for the hospital answers, and I said, you know, can you page Dr. whatever the doctor's name was? And the doctor didn't respond. So the receptionist says, okay, the doctor didn't respond, can I leave a message? And I said, sure. Attorney Kearns called, here's my number. Well, what patient are you calling about? And I said, he couldn't disclose that to me because of HIPAA, so because of HIPAA, I can't tell you either. And the response is, that's ridiculous. But sometimes people stretch it out to being ridiculous. I mean, you can't really talk about somebody's condition or their medical condition unless the HIPAA waiver applies. But you can always talk about somebody's name. But that's why I like to put the HIPAA waiver in the document, because people are fearful they're violating federal law by giving out information. I sometimes run into the situation where someone would say to me, well, I bring mom to the doctor because I'm the primary caregiver, and I've signed HIPAA waivers before, and mom has too, with Dr. Smith. And I'll look at the individual and say, great, Dr. Smith has a HIPAA waiver. Does the ER at St. Francis? Well, no. I said, that's why you want to have the universal HIPAA waiver, because it applies to somebody at the emergency room or any hospitalist, any doctor or medical professional who's treating you. So that's why we keep it simple and have those documents. they're required to act in the person's best interests. Years ago, I had a situation where the Hartford Probate Court named me as an attorney to represent a guy who was despondent. His wife had served him with divorce papers. He put his shotgun in his mouth and he pulled the trigger and he missed. And he blew off his face. And so he couldn't really communicate with people. And so they had taken a skin graft off of his thigh and wrapped it around his face. So at the time, it was Hartford probate judge Bob Killian. And so he named me as his guardian ad litem, meaning his guardian at law, to protect his interests, and a forensic psychiatrist from the Institute of Living to go interview this individual and find out what he wanted. And it was interesting because there's some staff people at the hospital that were furious that efforts were being made to keep this guy alive when he had tried to commit suicide. And you know, it was really trying to sift through the tea leaves to find out what this person wanted. But the reason why I'm telling the story is to answer Maureen's question. First of all, you had to find out if the person is competent or incompetent, which is why I went there with a psychiatrist. And what I got the gentleman to do is to move his head, either shake it affirmatively or negatively, so he couldn't carry on a conversation talking, but by nodding, I could understand what he was telling me. And that's typically what the probate courts will do, is if someone is competent, then we presume that they have the ability to make decisions for themselves in their best interests. And if they're not, then the Connecticut standard is clear and convincing evidence must be presented to the court to prove that the person is incapable. And that's the term we use in Connecticut, incapable, not incompetent. They're incapable of managing their affairs, their business affairs, like their assets, or they're incapable of making decisions for their person, such as hygiene, healthcare, shelter, and providing for their own food and nutrition. So that always happens if someone doesn't have documents. Then you're going to the probate court to have a conservator appointed. Within the last year and a half, I have steered my practice away from conservatorships because they've gotten prohibitively expensive in terms of they're very contested now. Some attorneys want the docs to appear in person to testify, or other times they are just contesting everything that's presented by way of evidence. And then next thing you know is it's costing $5,000 or $6,000 to put these cases on. And that's not the court-appointed attorney's fee either. And then you're getting into the probate court fees, which are $250 every time you go in there. And then if somebody has assets, you have to post a bond. If somebody has $100,000 of assets, the bond is close to $500 a year that you're paying to be bonded against stealing somebody else's money. And it can be a spouse who's the conservator for, you know, their husband, their wife, who might have dementia, who might have had a stroke and doesn't have documents. But every once in a while, I have somebody who comes in the office and they might be in their 80s, might be in the late 70s, and the conversation goes something like this. Well, you know, haven't done a will yet, haven't done a power of attorney, haven't done my healthcare instructions. And my response is, oh, you're Peter Pan. It's never gonna happen to you. You're never gonna get sick. You're never gonna die. It's the guy down the street or your next door neighbor that this is gonna happen to. And I always tell people, bad things happen to good people. And I'm not trying to belittle anybody, but kidding around and breaking the ice and trying to pull information out of them in terms of what is it that they're looking for, what kind of documents, and if they've thought about who would be good as the healthcare representative, who might be good managing the finances as power of attorney or an executor. Any other questions? Yes, sir. Well, here's the thing that's kind of tricky. Being the sarcastic guy that I am, anytime somebody dies with money, regardless of how they own it, they have to file paperwork in the probate court. You cannot avoid it. So, in the probate word comes from the Latin root to prove. What are we proving? That you were competent when you signed a valid will that was properly witnessed and properly executed. So we don't probate a will under Connecticut law unless somebody dies with more than $40,000 of solely owned assets or has real estate of any value. One time I had to go through probate because a client that had a multi-million-dollar estate that was in trust. When her husband died, there was a small lot. And when I say a small lot, it might have been the size of a driveway between two-family houses. And the assessor for the town of Manchester said it was worth $750. But we had to probate the will because it was real estate of any value. So when you go through probate, if the person dies with a will, it's called dying testate because they have a last will and testament. That's where the testate comes from. If they die without a will, it's called dying intestate without a will. If you die without a will, you have someone called an administrator of your estate because the executor executes and carries out the terms of the will. If all the executors are dead in your document where they're disabled, then you have someone called the administrator. So that's how you're going through probate with assets under a will, or if you have assets and you died without a will. If you have assets in a trust, or if you have assets all jointly owned with a spouse or someone else, you're still going to probate. And particularly if you own real estate, most people don't realize this, but just like the tooth fairy comes when you lose a tooth and puts money underneath your pillow, when you die, this magical lien descends from the heavens onto your property. And under Connecticut law, the title to that real estate is unmarketable until you go to the probate court, pay the probate court fee, and obtain a release of inheritance tax lien that you record on the land records so that now you can sell the property. And most people don't understand that because they're conditioned to believe, gee, if I own something in survivorship and that person dies, I automatically own the bank account, I automatically own the mutual fund, the stock, the bond. But if I own real estate joint with somebody and they die, isn't it mine? And the answer is no. It is yours, but you can't sell it until you get that release of lien. I'm saying you have a right of survivorship, but there's a lien on the other half. So if you want to talk about probate court fees, here's the fun news. First of all, the salt in the wound is that you're writing a check to the treasurer for the state of Connecticut, and they're telling you there's no tax. I always figure if it walks like a duck and it talks like a duck, looks like a tax to me. But when it comes to the probate court fees, if your spouse dies and everything is joint with your spouse and your spouse is the beneficiary on everything, the surviving spouse has the pleasure of paying 0.25% on everything that you list on the Connecticut estate tax return. And then if you're the last spouse to go, it's double or nothing. The kids pay 0.5% on everything that you owned when you passed away as the probate court fee. Yes?
I was under the impression that if it's in trust, you don't have to go to probate, but you're saying you do have to.
Let me tell you a quick story about the Great Recession of 2008, 2009. When I first started practicing back in '82, there was 133 probate courts, and we have 169 towns. Imagine that. I think we have 13 trial courts in the state, and we had 133 probate courts. And then the Great Recession came, and then there were about $5 million in the hole, and the hole was getting bigger. And what they decided to do after the Great Recession is to reduce the probate court districts down to 54. And they were in 60,000 population centers. So Hartford has their own probate court. But then there's the Tobacco Valley one, which is Bloomfield, Windsor Locks, Suffield, and East Granby. It's almost a circle around Windsor. And then you've got the Greater Windsor District, which is Windsor, East Windsor, and South Windsor. West Hartford has their own. And then you have the Greater Simsbury one, which is pretty much all of Farmington Valley. It's Canton, Avon, Simsbury, and Granby. And so they have these different probate court districts like that. But when the Great Recession came and they consolidated all the probate districts, there's this rule, and it's called the standards of title. Title is what the title searchers use when they're searching title. And so they changed the standard of title to say that if somebody dies with real estate in the trust, they still have to go to probate court to get that release of lien for the real estate. So even though you are doing your best for probate avoidance, you're then still filing the Connecticut estate tax return and paying the 0.25% or 0.5% as a probate court fee, even though the probate court did nothing except add up my math on the Connecticut estate tax return.
That's specific to just Connecticut?
Yes. Don't ask me about any other state because I don't know.
Is that what they call the death tax?
Pardon me?
Do they refer to that as the death tax? Is that like it's sort of like a tongue-in-cheek term, the death tax?
Well, in Connecticut, in Massachusetts, the death tax kicks in at $2 million, and Connecticut tracked the federal estate tax until the Great Recession. And in 2009, one of the queerest things that I've ever seen in the law happened. And that was on January 1 of 2009, the Connecticut estate tax, 2008, was going to kick up to 3.5 to track the federal exemption. So on January 1st, it goes up, and I had this conversation with a client. I distinctly recall it. And I said, gee, congratulations, your mom died with an estate of $3.3 million in January, and so it had just gone up from $2 million in December to $3.5 million in 2008. And I said, your mom just missed the Connecticut estate tax. And in June, the legislature says, retroactive to January 1st, we are moving back the $3.5 million to $2 million. Nobody was grandfathered in. So then I had to call up the client and say, guess what? You now have to write a check for $66,000 to the state of Connecticut because they just somehow, magically, underneath the Constitution, did an ex post facto law where they went back in the time machine and said, it was fine in January, in June it's not fine now, and you have to pay the tax. So from the Great Recession up until about 2017, we had a level $2 million Connecticut estate tax. And all of a sudden, the legislature realized that people were fleeing Connecticut like crazy. General Electric was gone. The rich guys down in Darien that worked at General Electric were gone. All these corporations were fleeing the high costs and taxes of the state of Connecticut. And so they started enlarging the amount of the Connecticut estate tax, where I think the first year might have been 2017, where it went 2 million to 2.2 or 2.5, and then it started to go up big. And over the last 2 years, 23 and 24, it's been uniform with the federal amount. And the federal amount right now is 13.61. And with inflation, on January 1st for 2025, it goes from 13.61 to 13.99. Are we having fun yet?
Sounds to me like, I'm getting an executive, but I'm not sure he could handle all the things that you're talking about.
Well, I do recommend getting an attorney. Some aspects of the probate you can kind of do it yourself. But when you're getting into settling an estate where there is an executor appointed, you have all these different steps. First, you have to file a petition to get the will admitted. And then it's like a cookbook. You have certain deadlines and you have to follow the recipe. 60 days after you're appointed as an executor, you must file an inventory saying, here's the value of all the assets in the estate. 150 days after you're appointed, you have to list all of the debts and all the creditors that are owed money. 6 months after the date of death, you file the Connecticut estate tax return. And then you file the final accounting. So usually in my practice, I have an awful lot of estates open at any one day of the week. And what I try and do as quickly as possible is file the inventory that's due at 60 days, along with the Connecticut estate tax return that's due in 6 months. I file that at the 60-day mark. And the reason why I file the Connecticut estate tax return is I'm not settling a lot of estates that are over 13.6 million. So if there's no tax, there's no deductions. You're just listing the value of the assets on the tax return. You're submitting it to the court, and they're sending you a bill for the dollar amount. And then what we do is wait until the 5 months go by, and when the 5 months time limit for keeping an estate open to allow the creditor to submit a claim expires, we're also filing the final accounting at the same time to close the estate out within the 5-month window. The only time that the estate might be open longer than 5 months is, number one, you have something you can't sell. In this market with the real estate, that's not the case typically unless there's something wrong with the property. Or somebody's trying to sell a business, or somebody has a claim. In my practice, I right now have a wrongful death suit that another attorney, a personal injury attorney, has brought for somebody who died in a motorcycle crash. It's not going to be settled in a 5-month window. And so what we do is keep informing the court at the different deadlines that this is a wrongful death case and there's pending litigation, and as soon as the pending litigation is resolved, we will close out the estate. So as long as you communicate with the court and let them know what's going on, they're not going to bug you. If either one of you pass away, the common route that you go through probate is what we call a TPO. And a TPO means tax purposes only. And that nickname came from the days of old, in the 80s and 90s, where if you were successful saving your money, you would file a Connecticut succession tax return that you'd send to the inheritance tax department. No, a child could inherit was $50,000. So you had 4 categories. You had AA, which was the spouse, no tax at all. Parent to child, $50,000, and then the rates went up. It started at 4.5% and then climbed. Then there was the B box, and the B was lateral: brother, sister, niece, nephew, aunt, uncle. And then C was stranger, so if your next door neighbor left you money, then after $1,000, 11% was the tax, would kick in, and it'd go as high as 20%. So the TPO means that with husband and wife, it's a felony under Connecticut law if you don't file the will within 30 days of someone's death, because public policy is we don't want people forging, altering, or fooling around with somebody's will, because that transfers property, transfers assets of value. So typically in the situation where husband and wife own everything jointly, 1, you're filing the will, and 2 is you're doing the estate tax return. Sometimes you may have the husband or wife owning a car solely in their name, or years ago they bought a MetLife insurance policy, and that was before MetLife went public. And then when MetLife went public, they issued trust shares or shares of stock to all these people that owned policies when they went public. Same thing with John Hancock, same thing with Anthem Blue Cross Blue Shield, used to be called WellPoint. I don't know what it's called now. They keep changing the name to protect the guilty. But in any event, the point of the story is you always run into these situations where you file the will, and if someone has some assets that are solely owned below $40,000, the car, shares of stock, the Christmas Club account, whatever it is, then you're filing what's called an affidavit in lieu of administration, saying, I don't need an executor, I don't need an administrator. As the spouse, I paid the funeral bill, and here's the funeral receipt, and I'd like a court order ordering DMV to transfer the car to me, or to tell Bank of America to give me the solely owned bank account that my spouse owns. That's the most common type of probate that I run into in my practice.
You name the attorney as executive?
No, I don't go for that. There's too many people that want to put their names all over your documents, and I find that that's unethical.
But the executive would work with an attorney?
Yeah. It's cheaper if the executor works with an attorney. I frequently run into this situation where somebody come in and an attorney will be named in the document, and I'll find out one of the kids is an engineer and another one is an accountant or a college professor, and I'll say to them, how'd you end up with the attorney? I don't know, he told me to put his name in there. And I almost think it's criminal when, if you think about it, the attorney might work with you for a maximum of 3 hours. In 1 hour, they get all the information, they draft the document, they send the document to you, and you come back for another hour or an hour and a half to go through the documents and sign it. And so on the basis of that 3-hour meeting, they're now in your documents, handling your estate and your assets. Since I'm on my soapbox, I'll mention one other thing that irks me, and that is when the lawyers hold the will for ransom. So now that you met the lawyer for 3 hours, the lawyer says, I'll hold on to your will for safekeeping. Well, my response would be, well, what happens if you die? What happens if you become disabled? Or what happens if you retire and move to Florida? Where's my will? In my career, I've run into several situations where the lawyer's lost it, or it's been burned up in a fire, or the lawyer retired and people threw out all his files and all his papers. And there's a presumption under Connecticut law, if we can't find your original will, we presume that you intentionally destroyed it because you didn't like it. So that's why you always hang on to your will, and you always put it in a safe place. Any other questions? Yes? Right. It's the same thing in Connecticut, and your point is, I didn't get any instructions, and I tried to cash a check on my deceased sister's account. And what people don't realize is that everything is frozen. And I always ask people this trick question: when does my will take effect? No. You know when the will takes effect? When the probate judge says it's valid. And during COVID, that was taken 4 months. So you're in limbo because the assets are frozen, you can't do anything, the person's died, the stock market's starting to go up and down and up and down, and you can't pay any bills until the executor is named, because then the executor takes the deceased person's assets and retitles them into the name of the estate of John Doe, or whatever the person's name is. So the executor has no control over the assets until they are put into the name of the estate. And then what they're required to do is go around and start consolidating the assets and also paying off the debt, whether it be paying the visiting nurses or the heating bill, the oil delivery, whatever it is. So everything comes to a screeching stop when somebody dies. Power of attorney dies with the individual as well, which is why the power of attorney is a different document than the last will and testament. And you're not an executor, and you don't have an estate open until the probate judge says that you do.
With our investment firm, we sign documents, rights of survivorship on 2 IRAs and maybe brokerage account. And then after that, we designate our children, secondary beneficiaries.
Which is the proper thing to do. The comment is, okay, at the brokerage firm, we have joint accounts. We have each other listed as the beneficiary on the IRA. We have the children listed as contingent beneficiaries. In 1997, the state legislature passed a law which allows for you in brokerage firms or mutual fund companies to have what's called TODS accounts. Transfer on death of securities. And you may have heard the term POD, payable on death, like with savings bonds before. You know, sometimes you look at the savings bond, it says POD. It's the same thing with securities, but only securities, not bank accounts, where you and your spouse can have the joint account, so if either one of you dies, it instantly belongs to the other spouse. But then to avoid probate, you have the TODS designation, so on the instant of the death of the survivor, the kids just have to come see the broker with a death certificate of the survivor, and the money is instantly theirs. And so that does not go underneath the will. Because again, remember, when you're going through probate, the formal probate process, that is for the management of solely owned assets. Assets that are non-probate assets, such as trust assets, life insurance, annuities, retirement accounts, those have designated beneficiaries, and all you're doing is presenting a death certificate, and then you have the instant gratification where the beneficiaries get the money instantly, no waiting. But when you have the solely owned assets going solely underneath the will, and those are being probated, you have to do the inventory, you have to show that you paid all the creditors, and then you do a final accounting showing what you did with the money, which is then approved by the court, and then you can close out the estate. So it's two different categories of assets. But what you're really trying to do to save time and money and energy is to have named beneficiaries on things. I always think that one of the worst things that you can do is put your child's name on an account with you. Because what most people don't realize is the child does not own a pro rata share of the account. So if you have $10,000 in the account, it's not $5,000 is yours and $5,000 is the kids. Anybody whose name is on the account owns 100% of it. So the bank is not there to be the referee and say, oh, you can only pull out 50%, you can only pull out this amount of money. Any person can take all of the money. But herein lies the problem. If your kid's getting a divorce, if they're going bankrupt, if they hit somebody with a car and they're in a lawsuit, there goes your bank account, there goes your house, there goes any of your assets, because you have somebody else's name on your property. And it's available to their predators and creditors.
So it's like if I would give my son the right to sign checks, like authorized to sign checks.
That's through a power of attorney. Right. A power of attorney in Connecticut, there's two types. There's one that takes effect the second that you sign it, and there's another type called the springing power of attorney. I've done thousands of powers of attorney in my career, and I can probably count on 10 fingers the number of times that I've done a springing power of attorney. Because what a springing power of attorney means to me is dad doesn't trust son to be power of attorney now. It's only when he's incompetent and doesn't know what's going on that he'll allow son to be in charge. But the rest of the time, the power of attorney, on its face, it's called a general power of attorney because there's powers that are listed there that you can perform. Or you can have a specific attorney, a power of attorney. I've had a power of attorney before where a client is going to Florida and they want me to sell their house. So they check off the box indicating that I can handle their banking transactions in terms of depositing the proceeds into their bank, and I can handle their real estate transactions so that I can go to the closing, sign their name on the deed, sign the closing paperwork, and put the money in the bank and wire it to Florida. And so that is a limited power of attorney because it limits what I'm able to do to a specific task. General power of attorney, it could be for anything. But the power of attorney takes effect the second that you sign it, typically. And there's three things that revoke it. Number one is you sign a new power of attorney that says, I revoke any prior power of attorney that I ever signed. Two is, in writing, you notify the agent that you have revoked the power of attorney, and you might record that on the land records and also give that to the banks that you do business with so they will not honor any previous power of attorney. The power of attorney dies when you die, and under Connecticut law, if a conservator is appointed in the probate court, a conservator of the estate, the power of attorney then is required to account to the conservator. Years ago, I used to represent nursing homes, and there'd always be somebody who was using a power of attorney to steal money from uncle or aunt or somebody like that. And it's called a breach of fiduciary duties because a fiduciary is somebody who stands in a position of trust, and they are supposed to act in the best interests of the principal, not their self-interests. And the way that you kill a power of attorney would be you'd go in and have a conservator appointed by the probate court. And the probate court always wants to know, does the person already have a power of attorney? And then if the answer is yes, they want to know, well, then why are you bringing this petition? Any other questions? No. Maureen, how are we doing on time? I guess we can end now if there's no questions. Well, thank you very much for your attention.
I'd like to thank everyone for coming tonight and all the people on the stream, and for Attorney Kearns for his wonderful talk. Lots of information there. The parish nurses wish to thank all of you for attending these sessions. In the new year, we plan to continue our series with a lecture to be given by a funeral director to discuss Catholic funerals, and then possibly one more to talk about our parish care ministry and how it supports everything that we've been talking about. These sessions will be announced in the upcoming months, so they should be in the bulletin and the emails. I'd also like to thank Pat Curtis for her support and technical expertise. Trying though it was at times, we still survived. We wish all of you a blessed Thanksgiving, a Merry Christmas, and a wonderful New Year. And please be safe going home. Thank you again.